Is that the
Did
decrease?
that matter?
Yes, Lord.
Okay.
I'm very deeply obliged, Lord.
May it please, your lord.
Yes.
Lord, may I pray for listing of a matter in motion, my lord, day after tomorrow, my lord? Because on 1st of July, the case is pending in the trial court for ex parte proceeding, my lord.
On which
Friday,
day?
on Friday, my lord.
No, no,
La-
no. When
First
the
of
case
July,
is
ma'am.
fixed before the trial court?
1st of July, my lord.
Trial. First of July. Okay.
Deeply obliged.
May I please, Lord? Also, in item number 45, we have filed an IA that is not on record. Yesterday, we have filed an IA.
Kobe.
Malad, I need to file a reply, Malad, in that so matter will come up
Have
after.
you received the copy?
Yes,
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 Lord.
we have received.
I have received a copy yesterday only.
Okay. As agreed by learned advocates of both the parties, recess shall raise the matter immediately after reopening of the vacation.
Malad, a date may be fixed, Malad,
Rest you will fix the date.
because Malad, this appeal, since it is an appeal, Malad, it doesn't come early, Malad. We have urgency in this. 16th of July. Much obliged.
May I please, your lordship? Lordship, with due consent of the other side, I beg to mention item number 22.
Item number
22.
22. Okay, Miss
V. Rai.
P. Rai, learned counsel for the E. Rai,
V. Rai.
learned counsel for the petitioner with consent from the other side. Press for Mr. Sutter, any objection? No objection. Press for listing the matter. After vacation? After
Lordship.
vacation.
Obliged.
Fair, Lord.
Mayor, I have to mention item number 9, matter. I am on behalf of Mr. S.C. Sharma, madam. He has some difficulties today, man.
Item number 9.
9, man. Immediately after vacation, madam.
Okay. On the pair being met, your name is not there.
My name is not there. I am on behalf of S.C. Sharma.
Mr. Konikor, learned counsel for the petitioner. No, for the appellant.
Appellant. First time, madam.
List the matter on
Immediately after vacation.
immediately after reopening of the vacation. Okay.
Deeply.
Yes.
May I please, your lordship? Lordship, I beg to mention item number 39, lordship. Lordship, I want to withdraw this matter with the liberty to file the civil revisions.
Item number 30,
39.
39.
Supplementary list.
There is statutory bar on the.
Yes,
I
lordship.
pointed
Yes,
out.
lordship. We have already prepared the civil revision. Lordship, I may be allowed to withdraw the certified copy, lordship.
Okay. Miss F. Ahmed,
Yes, lordship.
learned counsel for the appellant submits that she has the instruction to withdraw this appeal. Pair is accordingly allowed. This RSA instance disposal on withdrawn. The certified copy filed along with the appeal shall be returned to the appellant.
Lordship, with the liberty to file the civil revision.
However, liberty will remain with the appellant to approach this court again by filing appropriate petition.
Deeply obliged.
May I please, your lordship? I beg to mention for listing of a MSA appeal of
When?
134 of before vacation, lordship, any day this week or next week.
Is there any urgency?
Lordship, it is fixed for admission and
Admission after vacation. Take a date from him.
On 21st July. Item withdrawal, item number 36.
Your lordship, the matter may be taken up after some time, as my senior is on leg. Maybe.
This is withdrawal matter.
Yes, lordship.
Why your senior is necessary?
She have instructed that she will appear.
Why? For withdrawal? Okay. 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 Let her remain present.
For motion, item 1.
May I please, madam? The case is registered on the NDPS segment with the second application.
Second
Second
application.
application, started case, my lord.
What is the ground?
Actually, my lord, after filing of the case, we know that we came to know that this is it should be the second application. So we could not annex the from our earlier judgment and.
You annex it. You annex it.
My lord, that We are behind the bar for more than 290 days.
More than
More than 290 days.
299 days,
290 days.
290 days.
290 days.
Anyway, we'll say you enclose the earlier copy, earlier rejection order.
Fine.
Heard, Mr.
Neelam Pankaj Duara.
Lankesh, learned counsel for the accused. List the matter on Friday,
Oh,
so as to enable him to enclose so as to enable him to bring on record, earlier rejection order by filing an additional affidavit.
On 27th.
hello, right.
Charge sheet number regarding charge sheet is also not mentioned in the petition. It's difficult to say.
We'll
whether-
mention it in the
We
additional
will
affidavit.
enclose. Hello.
For motion item number 2,
May it please your lordship. Lordship, here I am for the waive lordship, I am seeking transfer of the case lordship from Sribhumi to Guwahati lordship. I have received a summon that is on page 40 lordship. And the ground for lordship seeking the transfer that is on page 9 para 8 lordship.
It belongs to which place?
From Sribhumi. This petitioner lordship now staying at Guwahati lordship. Earlier lordship 2000 lordship 23 she 2021 lordship
Where
she
the,
left,
where the respondent is residing?
Sribhumi lordship. Now lordship, what happened lordship? I have filed lordship two case lordship, one DB case that is pending here lordship, and one 125 proceeding that is also pending before this lordship in Guwahati lordship. Now they have received the summon lordship, they didn't appear lordship. Rather they appearing lordship, they have challenged the two case lordship by transferring one transferring petition and another for quashing of that lordship 125 proceeding lordship. Now lordship, that in both the cases lordship, court has issued some notice to the respondent lordship. Now, lordship, this present case is lordship, she is staying here, lordship, because of torture, she left the house, lordship. Now took shelter Guwahati at a rented house, lordship. Now her lordship, only daughter, lordship, now staying, lordship, studying at Bluebird in Guwahati, lordship.
Okay, we will issue notice, but we will not grant any stay at this stage. We will see we will hear the other side.
In the meantime, lordship, because of
No.
lordship, there is a court has
But,
allowed
that's
time
okay.
to file the written statement, lordship, because lordship, this
But the other side-
320 lordship, 320 kilometers lordship from Guwahati to appear in the Sribhumi lordship, because she has no one to escort her lordship to Sribhumi lordship.
Is it the
From
requirement that on each and every that she has to remain present there?
Now lordship thinks is there two cases pending here, lordship. They have lordship taken
Okay,
the.
we will consider it. Let the other side appear, we will see. Heard Mr. B. Chaudhary, learned counsel for the petitioner. In this petition under section 24 of the Code of Civil Procedure, the petitioner has filed for transferring of title suit number 435 of 2024 pending before the Court of Learned Civil Judge. Junior Division number 2, Sribhumi. Mr. Chaudhary, learned counsel for the petitioner, submits that the respondent herein is the husband of the petitioner who had executed the title suit number 435 of 2024 before the Court of Learned Civil Judge, Junior Division number 2. For what purpose it was filed?
But that lordship for one TB case lordship, another 125 proceedings.
This proceeding,
This is for dissolution of
suit.
marriage lordship. Dissolution of marriage by the husband lordship.
for dissolution of the marriage between the petitioner, between the respondent and the petitioner. Between him and the petitioner herein. And that presently the petitioner is residing at Guwahati. And two more cases are also pending between the same parties at Guwahati. And as such, no, and it is not possible on the part of the petitioner to contest the aforementioned proceeding before the court at Srironi. And as such, Mr. Chaudhary has contended to allow this petition. Madam, the submission of Mr. Chaudhary needs further consideration and this is such notice be issued to the respondent returnable in 4 weeks. They be taken by registered post with AD and also by usual process. We can never come to that. In view of the submission of learned counsel for the petitioner and also considering the fact that two more cases are pending between the parties in the court at Guwahati, this court is inclined to state further proceeding of title suit number 435 of 2024 pending before the court of learned civil judge junior division number 2 Srironi stands state in returnable date. List of reports.
Highly obliged, Lordship.
Item 36 for withdrawal. May it please your lordship, in this matter, lordship, the title suit was already withdrawn, so this CRP IO is against injunction, lordship. This one,
Heard Ms. Chaudhary, learned counsel for the
lordship,
applicant.
the trial court's order, lordship, on compromise, they have withdrawn the matter, lordship.
Ms. Chaudhary submits that. The impugn order passed by the learned, which was passed by the learned trial court in TS number 89 of 2022 has already been withdrawn by the parties
The suit of the plaintiff is decreed on compromise
on
with
the
some
strength of withdrawn or compromise.
compromise, lordship.
Compromise. And on that strength, one decree was passed. And as such, this civil revision petition become in practice and the petitioner is willing to withdraw the same. Having taking note of the submission of Ms. Chaudhary, learned counsel for the petitioner, this court is of the view that there is sufficient ground to permit her to withdraw this petition, and accordingly, this petition is thus disposed of withdrawn. Ms. Chaudhary has produced one order dated 27/1/2025, passed by the learned trial court before this court, and the same shall be part of the record.
Lordship, I'm deeply obliged.
Item number 3. May it please your lordship. So, this is a transfer petition praying for transfer of a divorce proceeding from the court at Morigaon to Sagar, my lord. Now, I am the wife, my lord. The marriage was in Namti Sayali in Sibsagar, my lord. We were residing in Sibsagar. My lord, a domestic violence case was registered, my lord. It was ruled in my favor. Thereafter, an appeal was preferred. If my lord comes to the appellate court's order, my lord,
Where the opposite party is residing?
the husband now resides in Morigaon. He's a junior instructor in the Morigaon Polytechnic, my lord. My lord, it's filed under the Hindu Marriage Act. So if my lord takes up section 19 of the Hindu Marriage Act, it does not provide for the husband's place of residence until and unless the wife is not heard of as being alive for the past 7 years, to file it at a place of his choosing. If my lord takes up section 19 of the Hindu Marriage Act. Or, sorry, my lord, my lord, I may provide this. Of us, assess. If my lord takes up section 19, my lord. Court to which the petition shall be presented. Every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction. Number 1, the marriage was solemnized, or 2, the respondent at the time of presentation of the petitioner resides.
Where the marriage was solemnized?
Namti Sarili in Sibsagar, my lord. I have
Sibsagar.
stated, I've stated so also. And also it is recorded in
So
the,
at no point, after the marriage, at no point of time you reside with
No.
the respondent in Morigaon?
no, my lord, at no point of time. And in fact, if my lord comes to the appellate court's order on the DV case, my lord, it's clear from that. There was an extramarital affair.
Heard Mr. Nair, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring of titles of D number 75 of 2024, pending before the Court of Learned District Judge Morigaon, the Court of Learned District Judge Shivsagar, Assam. Shivsagar, Assam. Mr. Nair, learned counsel for the petitioner submits that the petitioner is the wife of the respondent hearing who instituted the divorce proceeding paying titles of B number 75 of 2024 in the Court of Learned District Judge Morigaon, Assam. And that the marriage between the petitioner and the respondent was solemnized at Shivsagar. And at no point of time she resides with the respondent at Morigaon. And as such, only the court at Shivsagar has the jurisdiction to try the suit. The submission of Mr. Nair needs further consideration. It is notice be issued to the respondent, returnable in forms that be taken by registered post with ADN also the usual process. And taking note of the submission of Mr. Nair, learned counsel for the petitioner, and also considering the facts and circumstances of the record, till returnable that further proceeding of titles of D number 75 of 2024 stands state till returnable date list of proposals.
Deeply obliged.
Item 4.
Lordship, my senior is in court 11. Kindly matter be passed over for the time being.
Items for admission, item 5, Parthad Meter.
In this matter, CM Sharma will appear, he is on leg mine after some time.
Lordship, last occasion, Honorable Court, please to direct it to furnish the documents annexer 1, 2, and 3, Lordship. 1 and 3 has already submitted. 2 has not been submitted. Let them after vacation, Lordship.
Why?
Documents.
Okay.
No.
No, whether the document is available.
So let them then my friend learned counsel. Yes.
Let Mr. Sharma come.
Yes, Lordship. Yes, sir.
Item 6, Parthad Meter.
I took time to file affidavit and economic doesn't file affidavit file on Monday. And government is could be also sub So some matter. And it is getting production of the select list by the state government. They have not produced the select list, original select list.
Original select list,
They
not
are-
produced.
Not, they have to produce it. And it is their property, my lord.
Yes, Mr. Sharma. You are appearing here,
Yeah, elementary matter.
elementary.
Yes.
Who is appearing for elementary?
And my affidavit is on record, my affidavit may be on record.
Ian Sharma will be appearing.
Yes, he is on leg.
Okay. Wait,
He also requested Miller, he is in another court, sorry, Miller, another court on lake. So either Miller, maybe after vacation, Miller and
after vacation, okay. As agreed by learned advocates of both the parties, this is the matter immediately after you continue the vacation.
with affidavit, Miller, yes. With affidavit, I have filed.
Pardon?
File Miller Monday.
Pardon?
I have filed affidavit on Monday, that may be take two, must.
Item 7.
Affidavit.
After Miller 17 or 18 Miller July.
Okay, learned counsel for the petitioner. Filed by the learned counsel for the petitioner shall be
Take.
placed on record on next day.
17 or 18 Miller in rulership,
23rd July.
20,000, my lord.
Item 7.
In this matter, an instruction has come from the elementary department to the, it is written to the secretary of the government.
You? So, Mr. Alam, what was your pair in this petition?
For monthly pension, my lord. In terms of the earlier order of this honorable court, my lord. Page 18, my lord, prayer number 2, my lord. Maintenance shall not be issued direct responsible to release the monthly pension of the petitioner from the date of retirement 31/12/2015. That is page 18, my lord. I am praying at prayer number 2, my lord. Since first is he is already retired from the service, so it's not required, my lord. From the date of the provisions of the Assam Service Amendment mandated by the Honorable High Court order dated 14/12/2015, passed in WPC number 2284 of 2013. And also release the retirement benefits, my lord. That is yet to receive by the petitioners. I am pressing 2 and 3, my lord.
So you have been receiving pension?
My lord,
You have been receiving pension?
my lord. NPS, my lord, now they have NPS, my lord, but under by this order of this honorable court 14/12/2015, by counting the past service, my lord, they will be entitled for the pensions under Assam Service Pension Rule, my lord. That order I have also annexed, my lord. And that order is also, my lord, on the basis of a judgment rendered in 2008.
That's all right, but have you seen this instruction? Furnish a copy to him.
Yes, yes.
So they have decided to count your past service
My lord,
towards pensionary benefit
my lord,
as per the Assam Service
Pension
Pension
Rule.
Rule
1969.
1996.
No, 1969.
69, my 1969, my lord. It's a
It is
typographical
wrongly
mistake, my lord.
1696.
Hmm.
1960.
1969, my lord.
So you go through it,
My lord.
then you inform this court, you have any other grievance? So, Mr. Sharma, when they will entitle to benefit as per this letter?
No, this instruction is, this letter is written on 24/6/2024, no 25. It is under, now it is under the office of the government, my lord. So
Hmm.
sometime may be required, my lord, after vacation, my lord.
after vacation.
Yes, I have no problem, my lord. By that time, they will release my pensionary benefit. Since he has already retired from the service, my lord, 2023, my lord.
No, you are receiving provisional pension, provisional. or
No, no,
final?
my lord, nothing, my lord.
Nothing.
No, my lord.
Under NPSA, you have receiving nothing.
No, my lord, nothing. Since 2023, he is retired from the service, 31/12/2023, my lord. But since then, he has done nothing received, my lord. No provisional pension, nothing, my lord. Yet this lordship may also direct them to release the provisional pension, my lord, by counting my past service, my lord.
No. My lord, there is dispute regarding the whether he is entitled for NCP, NPS or old pension scheme.
That was entitlement was already decided by this honorable court in earlier round, or petitioner is one.
See this instruction.
Yes, yes, madam.
Last part.
So this letter has written to the government, now it is under the government. Government process.
By that time, they will, my lord, obtain instruction, my lord. Your lordship may fix after vacation. my lord.
After vacation.
I have no objection, my lord.
Okay.
At least they will,
Get the status of the.
if possible, if they will release, my lord, at least provisional pension, my lord.
Okay.
Your lordship may have some
Heard
observation.
Mr. Ayalam, learned counsel for the petitioner, and Sir
Since, my lord, entitlement is there.
U. Sharma, learned standing counsel for the respondent in
Secondary.
Secondary Education Department, and Mr. Sharma for respondent number. Oh,
Yes, he
and
respondent number, my
Mr.
lord.
Gogoi for respondent number 3. You are? Four. PM4. PM4. During the course of hearing, Mr. Sharma has produced, U. Sharma has produced one letter written by the Director Elementary Education, Assam, to the Secretary to the Government of Assam Department of School Education. And submits that the person to the letter of the government, the office of the director has issued an order to the effect that past service allowed for counting towards pensionary benefit as per the Assam Services Pension Rule
1969.
1969. 1969. And he may be granted some time to obtain the latest status of the aforementioned proposal of the Director of Elementary Education. Where is accordingly allowed, SSL is the matter on 23rd July. 23rd July. So you obtain up to date instruction on that day.
Yes, sir.
And in the meantime, if possible, the respondent authorities shall release the provisional pension of the petitioner.
Highly obliged, me.
The letter produced before the court shall be part of the report.
Item 8. Obliged, me.
May I please, your lordship?
Madam, in this matter, instruction from the elementary department has not come. Well, sometime.
Heard Ms. M. Sharma, learned counsel for the petitioner, and Ms. U. Sharma, learned counsel for the respondent in Secondary Education Department. Mr. Sharma submits that instruction from the Elementary Education Department is still awaited. And a press release in the matter after vacation,
After vacation.
after immediately after reopening of the vacation. Here is according to the law, SSL is the matter immediately after reopening of the vacation.
Highly obliged.
Item numbers 37 and 38.
Item number 13.
Lordship, here is that's in court number 4. Might not be taken for timely.
We have to only, Lordship may admit this appeal. Lordship, actually, we have exchanged our copies. In item number in item number 37, we are the appellant. And in item number 38, they are the appellant. And it regards to same order. We have challenged the order dated 29/10/2022, passed by learned civil judge Jorhat in money suit number 2.
So, whether she has an instruction or not, that has to be obtained. What is your instruction?
Lordship, timing will be.
I'm saying, okay, time.
Obliged.
Standing as a floor for motion.
I'm sorry, my lord, I was in another court. So, my lord, I have collected another document on medical ground, my lordship. Kindly see. My lord, limited humble prayer before lordship is dead. Only one witness is to be only cross-examined, my lord. That much, my lord. Only for one occasion, on medical ground, my lord. I was in hospital and my wife submitted the application for adjournment that was not allowed, and review petition is also dismissed. I pray only one opportunity to examine the official witness. That much, my limited prayer, lordship may kindly consider, my lord.
No, this certificate is obtained on 23rd of June.
No, earlier certificate, all the certificates I have annexed. Recently, I have obtained the certificate as your lordship passed the earlier occasion, my lord, order, my lord. Last order, my lord. I again visited the hospital, my lord.
The order of this court is to show any medical document to show
Lordship,
that after
Yes,
being released from the hospital,
yes,
he was
that,
not
that
in a
order is there,
position
my lord.
to
That order
appear
is
before
there.
the court.
My lord, lordship may kindly see the page number 44 onwards, my lord.
Mhm.
All the orders, all the medical documents I have annexed. Page number 44 to
Those
52.
documents are there, but
After discharge also, he visited continuously in the hospital, my lord, in his critical condition due to head injury and head operation, my lord. Page number 44 to 52, my lord.
no. Whether these documents shows that at a relevant point of time he was bedridden.
My lord, when a patient, my lord, in generally operation was done, my lord.
No,
Lordship may
forget
kindly
about
see.
generally or usually.
My lord, lordship, page number 45, when the incident was taken place, a mark has been, my lord, given by the doctor. Lordship may kindly see page number 45 in the advice column, my lord, right hand side, neurosurgery is required, my lord, for head operation. Neurosurgery, page number 45. And after examining the critical condition of the patient, neurosurgery is required, page number 45. And
No, you were
thereafter,
repeating the
my
same
lord,
thing. You were repeating the same thing.
no, my lord, I am not repeating. I'm just pointed out. I'm sorry for that.
Hmm. On the other day, you could not satisfy this court with the documents plus some record that he was bedridden at the relevant point of time. And today you are repeating the same thing.
My lord, I am sorry.
Hmm.
So lordship has examined the entire medical record, and as well as recently I have obtained a copy which I have collected, my lord. My lord, till now he is visiting the
Well, let
hospital.
notice go, let the other side appear.
My lord,
Heard,
only
Mr.
only limited prayer, my lord. My lord, one opportunity may be given, my lord.
We have already afforded an opportunity to you to produce a medical document. You have failed to produce it.
My lord, not only for medical document, I am praying it is up to your lordship. One opportunity, otherwise for my lord, proper adjudication of the case, my lord, only one witness's cross-examination is required, my lord, for proper adjudication, my lord. On that day, my lord, the witness came, my lord, and sleep was done, my lord, and he was discharged, my lord. Only cross-examination, that part, lordship, it is up to your lordship, my lord. Humble prayer.
Heard, Mr.
Yeah, my lord.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 10/6/2025, arising out of order dated 22/4/2025 and 24/1/2025 in PS number 162 of 2013. Pending before the Court of Learned Civil Judge, Junior Division number 1, Dorong Maholder. It is to be noted here that by the impugn order dated so and so, the learned trial court has close the evidence of the defendant number 2. Without giving any opportunity of cross-examination to the present petitioner. Whereas the petition and the documents placed on record, let notice be issued to the respondent, returnable in 2 weeks. Step be taken by registered post with KD and also the usual process, returnable from to that. Thus, the service is also permitted. After effecting service upon the respondent, the learned counsel for the petitioner shall file an affidavit before this court. List after 2 weeks.
And further proceeding, my lord, till next date, my lord, further proceeding, my lord.
No.
Item for hearing under order 41, rule to CPC.
Please, Your Lordship, kindly the matter may be passed over for the day.
For the day.
Yes, Lordship.
Okay. The pair being made by Ms.B. Azurita, learned counsel for the appellant, the matter stands over for the day.
Your Lordship, kindly a date may be given.
Take it. Comment.
Item 39. Sorry, item 11.
Well, this is an appeal for enhancement of the compensation paid. But may I play this matter be taken for
Whether you have taken a step upon respondent number 20.
my lord? My lord. Lord, they have also filed cross appeal, my lord.
Mr. Sharma, you are for respondent number 1.
Respondent number 1.
Mr. Ardube, learned counsel for the appellant, and Mr. Sharma for the respondent number 1. Office note dated 23rd June 2025 indicates that the service notice upon respondent number 2 could not be served, as the address could not be traced out. Mr. Dubey, learned counsel for the appellant, is directed to obtain instruction and to take step step upon respondent number 2. Though the office note dated 9/12/2024 indicates that service record upon respondent number 3 and 4 awaited, yet the office note dated 23rd June 2025 is silent about the status of notice issued to the said 2 respondent. There are only three respondents.
My lord.
This office note seems to be incorrect. However, perusal of the record indicates that there are only 3 respondents, and 1 has already entered appearance. Mr. Dubey, learned counsel for the appellant, is also directed to take passive upon respondent number 3.
3, my lord. 3.
Step be taken by registered post with AD and also by usual process within a week from the list of the 4 weeks.
Item 12.
May it please your lordship. Lord, as per office note dated 19/6/25, lordship, respondent number 1 and 2 duly presented, and AD of respondent number 3 has not been received back, lordship. And notice was issued on 6/5/24 only, lordship. Maybe awaited, lordship.
Ordinance M. Sodore, learned counsel for the appellant. Office note dated 19/6/2025 indicates that one counsel entered appearance on behalf of respondent number 192 by filing a color number, but they remain unrepresented today. Side of also indicates that AD card in respect of respondent number 3 is still awaited. Unless the matter after 2 weeks awaiting service report upon respondent number 3.
Lordship. Must oblige, Lordship.
Item 13.
Had order dated 20/6/2025, substitution of the legal heir of the respondent number has been allowed. And accordingly, I was directed to submit the amended cross title, and we have filed that is on 21/6. Lordship. So here, Lordship, in the appeal, the appellant has challenged and ordered Annexure 6, by which the substitution application has been rejected on the ground that no separate application for condonation of delay has been filed. In the meantime, during pendency of this appeal, both the parties has amicably settled the dispute in between them. So in that view of the matter, so the respondent has now no objection in setting aside this order. Lord. Annexure,
Where is the deed of settlement?
deed of settlement is.
Is it not necessary to bring on record this and date?
Maybe that will enough, Lordship, because we have to submit the this deed before the lower court for passing a compromise decree. Lordship. Because suit has been stayed, therefore the parties could not able to file the petition for passing the compromise decree. Lordship. In the suit, the appellant's predecessor was arraigned as a pro forma defendant. He died during the suit, but the plaintiff has also not taken step for substitution of the pro forma defendant. So therefore, the legal heir of the pro forma defendant by their own submitted application for substitution, their substitution, along with a setting aside an abatement application. But due to inadvertent mistake on the counsel, he has not filed the application for condonation of delay of 131 days in filing that application. So therefore, solely on that ground, that applications were rejected by the impugn order.
So we have to allow this appeal.
Yes, Lordship.
Yes, any objection?
Lordship, I am appearing for the response, substituted respondent number 1, 1, 2, and 1, 3. So I have no objection in allowing the prayer, since because I have not filed any objection in the trial court itself regarding their prayer, which was rejected.
Heard Mr. S. Decker, learned counsel for the appellant, and Mr.
PM Decker.
PM Decker, learned counsel for the respondent number 1A.
1, 2, and 1, 3.
1, Roman 1.
Roman 1.
Roman 1, Roman 2, and Roman 3, and Mr. D. Chaudhary for respondent number 2, 3, 4, and Mr. Gogoi for
Number 6 and 7.
6 and 7. 6 and 7. 6 and 7. Mr. Decker, learned counsel for the petitioner. No, counsel for the appellant submits that his appeal was preferred under order 43 rule 1K of the Code of Civil Procedure, challenging the order dated 10/3/2023 passed by the learned civil judge Lakhimpur in petition number 1253 of 2022 and petition number 1254 of 2022 arising out of title suit number 13 of 2018. Is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed under section 5 of the Limitation Act as the petitioner has failed to explain the delay in filing the two petitions. Mr. Decker, learned counsel for the appellant further submits that during the pendency of this appeal, both the parties have settled the matter amicably, and they have also executed one deed of compromise. And has produced the same and produced a copy of the same before this court. And contended to, and on the strength of the same, Mr. Decker has contended to allow the appeal. Mr. Decker, learned counsel for the respondent, 1112 and 13. And Mr. Soduri for the respondent number so and so, and Mr. Gogoi for the respondent number so and so submits that they have no objection in the event of allowing this appeal. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, and also the deed of compromise orders before the court by learned counsel for the appellant. And further, considering the grounds mentioned in the petition, this court is inclined to allow this petition as the delay in filing the petitions stands explained in the petition. In terms of this appeal stands allowed. The
Impugn order,
deed of compromise orders before this court shall be
impugn order
part
has to
of
be
the
set aside.
record.
Impugn order has to be set.
Impugn order dated so and so set aside.
Date may be fixed before the lower court lordship.
So, when the next date is fixed,
No date lordship because proceeding has been stayed.
the parties are directed to appear before the learned trial court.
July lordship.
Suggested that
Any day in 10th it will be beyond 10 July. Obliged.
respondent number in this
Secretary,
appeal,
yes, Secretary Revenue.
Mr. Jay Hendik for respondent number 5.
Item 14. Obliged.
May it please your lordship, we have handed over the entire brief on 11/6/2025 to the applicant, and they have collected it. We are no longer engaged in this case.
May I see your good name, please?
S. Dasgupta.
Ms. S. Dasgupta, learned counsel for the applicant, and Ms. B. Azarika, learned counsel for the respondent number 2 and 4. Ms. Dasgupta, learned counsel for the applicant submits that she has handed over the brief to the applicant. But the applicant remain remain absent today. And in view of, I hope it is provided, necessarily issue notice to the applicant by registered post. And list the matter after 2 weeks. The name of learned counsel for the applicant shall be deleted from the list.
Item 15. Lordship, FR office not dated 19/6 lordship. Respondent number 2 is not found lordship. And 3 has refused. So 3 service is complete lordship. 2 lordship, we will have to take a step on proper address. It is not found, it is written. And answer is also not.
Lordship deposited award.
Mr. Is this okay?
Lordship
Learned
deposited award.
counsel for the appellant and Mr.
A. Iqbal, correspondent number 1.
Learned counsel for the respondent number 1.
1.
Respondent number 1 of this note dated. Of this note dated 19/6/2025 indicates that Respondent number 3 refused to accept notice. In view of above, notice upon respondent number 3 into a consent. And in respect of respondent number 2, the said office note indicates that the address could not be found. So Soikia Learning Council for the appellant submits that he will take passive step upon respondent number 2 after obtaining necessary instruction. Accordingly, it is provided that step upon respondent number 2 be taken by registered post with AD and also the usual process within a week from today. List on matter after 4 weeks.
Your lordship, as per.
LCR may be reminded, Lordship.
Pardon?
LCR may be reminded, but LCR not comes.
Registrar also issue reminder to the learned tribunal for transmitting the record without
Your
further
lordship,
delay.
as per order dated 21/6/2024, the claimant respondent shall be in the liberty to withdraw the award, your lordship, 30% of the award. In the present appeal, your lordship.
Also, this is in IA, Lordship. IA is dear, Lordship.
There is that.
But driving license defense is dear, Lordship. Driving license are not valid. If the amount is released, Lordship, it may be subject to bond, Lordship.
You have deposited the amount?
Yes.
When?
As per my instruction, Lordship, on 4th of last July, last year.
Heard Mr. A.J. Soikia, learned counsel for the applicant, and Mr. A.N. Iqbal. Oh, no, A.N.
Iqbal.
Learned counsel for the respondent number 1. Respondent opposite party number 1. Mr. Iqbal submits that pursuant to order of this court dated 21/6/2024, the appellant in MSC appeal number 269 of 2024 has deposited 30% of the awarded amount. Awarded amount. And the applicant. No, and the respondent herein, respondent number 1 may be allowed to withdraw the aforesaid amount. Taking note of the submission of learned counsel for both the parties, it is provided that on executing upon the equal amount, the aforementioned, the amount being deposited before the registry of this court shall be released in favor of the respondent number 1. To execute on both.
IA, Lordship, may be disposed, Lordship. This IA is disposed, Lordship.
In terms of this IA is closed.
Obliged, Lordship.
Obliged.
Pending item 5, partner matters.
Ma'am, Lordship. Lordship, my friend, learned counsel.
The lordship directed me to
Receive the instruction.
lordship. I have received enclosure 1, 2, and 3. Lordship will say, 5 page is the dash report. Where 9, 10, there is only the dash capture format. And the 11, 10, 11 is a school report card. As my learned friend for the SSA submitted on the last occasion, that the format is required, that report card is required. And lordship, the vernacular one is the inspection report, lordship.
So, Mr. Sharma, Mr. Das has applied for listing the matter after vacation.
Lordship, lordship.
So you furnish a copy of this document. Yes, Mr. Das.
Lordship.
And we will hear the matter after reopening.
Lordship, lordship. As a part of my lordship.
Okay, third, Mr. Arsidas, learned counsel for the petitioner, and Mr. Vivian Sharma, learned standing counsel for the respondents in elementary education department. Pursuant to direction of this court dated 18/6/2025, Mr. Sharma has obtained the enclosures of the letter dated. What is the date of this letter?
This letter, that communication dated. It is in fact. Page number 37 after liquidation. Lordship, this is of
13 to 20, 2014.
Yes, 13.
13 to 2014. A copy of the aforementioned letters be furnished to Mr. Das, learned counsel for the petitioner, and places a list the matter on as further.
Lordship.
Yes, further. The documents for this we would report to this shall be marked as document number A, and be placed on and shall be enclosed with the record.
Much obliged.
Pending items 37 and 31, 37 and 38.
May it pleases your lordship. Hello, this first appeal, my lord. Both the parties have approached this honorable court, my lord. The suit was decreed partly. Against that decree, we have Corporation of India has filed this present appeal RFA number 29 of 2025. And they have also come for their main relief, my lord. My lord, the matter may be admitted, my lord, and LCR may be called for.
You are in item number?
30, I'm in item number 38. My appeal is item number 38, RFA number 29 of 2025.
RFP number?
29 of 2025.
Okay. Yes, you are in
And-
28.
Item 37.
Heard.
Oh,
Heard, Mr.
BP Sharma.
Learned counsel for the appellant, and also heard.
DK
Mr.
Singh.
Your name is not there in the cause list.
Lordship, on behalf of R. Hazarika, Lordship.
R.
Hazarika.
R. And Mr.
DK Singh.
DK Singh, learned counsel for the respondent. For all the respondents?
Yes, my lord.
For the respondents.
Lordship, we already have exchanged our copies, Lordship. Already have served.
This appeal under order 41, rule 1. Read with section 96 of the Code of Civil Procedure is part. Against the judgment and decree dated 29/10/2022 passed by the learned civil judge, Durat in Manisab number 2 of 2014. There is a memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents. However, no formal notice is required to be issued since Mr. So-and-so entered appearance and received notice. However, extra requisite copy of the memo of appeal will be furnished to him during the course of the day. Rest is call for the record from the learned court below. List the matter after 4 weeks. After 4 weeks, same order in RFA number 29. 29 petitioner is Mr. Singh. Appellant is Mr. Singh.
Like that.
Obliged.
Number 16.
Three petitions were filed. One is delay continuation petition in setting aside the abatement and the substitution petition. The appellant number 2 has died. So to substitute the legal year, we have filed 3 applications. On the last occasion, on 9/12/2024, notice was issued on the respondent in delay application.
Whether all the parties entered appearance. You were for respondent number?
Respondents one. For the respondents one.
Both the respondents.
Yes, ma'am.
Okay. Any objection?
No matter.
No objection. Heard Mr. Biswas, learned counsel for the applicant in ISA bill number 969 of 2024. This application under section 5 of the limitation is preferred by the applicant for confirmation of delay of 42 days in filing and setting aside abatement petition. Mr. Business Learned Counsel for the applicant submits that submits that during the pendency of the RSA number 6 of 2015, appellant number 2. What is the name?
My lord, Srimati Parvati Devi Khakolia.
Parvati Devi. Passed away on 11/9/2023. And due to lack of knowledge about the requirement of substitution, the information regarding the date of appellant number 2 could not be obtained in time, could not be made in time. And that the delay is not intentional, rather it is circumstantial, and under such circumstances, he has consented to allow this application. Mr. Your good name?
GFTS, my lord.
GMPS Learned Counsel for the respondent submits that he has no objection in the event of allowing this application. We are taking note of the submission of Learned Counsel for both the parties and also taking note of the ground of delay. So explained in the petition, this court is of the view that the delay is sufficiently explained and accordingly this application stands allowed in terms of how this IA stands disposed of. In IA number 972. This interlocutory application under Order 22, Rule 2 of the Code of Civil Procedure is preferred for substitution of the name of appellant number 2. For substitution of the legal heirs of the appellant number 2 who suffered demise on 11/9/2023. Mr. Business Learned Counsel for the applicant submits the appellant number 2 suffered demise on 11/9/2023, leaving behind one Sri Amrit Khakolia and Ashish Khakolia and Srimati Arsana Arora as our legal heirs. And the said legal heirs are required to be written record in place of the appellant number 2. The Learned Counsel for the respondent opposite party number 1 and 2 submits that he has no objection. We are taking note of the submission of Learned Counsel for both the parties and also considering the facts and circumstances on the record. This interlocutory application stands allowed. The three legal heirs of the appellant number 2 shall be updated as respondent number 2, 1, 2, 2, and 2, 3 in the RSA number 6 of 2015. In view of the order passed in this interlocutory application, Mr. Business shall file amended cost title within a period of 1 week from today.
Yes.
RSA number so. This abatement. Okay.
Much obliged.
Item 17.
May it please your lordship. Your lordship, may peruse office note dated 23/6/2025, your lordship. Respondent number 1 has filed his wakalatnama, but as regards respondent number 3, your lordship, unserved notice has been returned without any postal note. And as regards respondent number 2, your lordship, service is not completed. So, your lordship, I pray that we may be given some time to take steps to dusty service, your lordship, upon respondent number 2 and 3. Since we are denying both quantum as well as liability, your lordship, so they are necessary party here.
Witness P. Borthakur, Lord and Counsel for the applicant.
My lord, we are appearing for the respondent. Here, my lord, in this case, the driver and owner, my lord, they did not turn up before the NSCT because insurance coverage is there. In most of the cases, we find, my lord, when insurance cover is there, driver owner don't turn up. They don't contest. So only there will be delay, my lord. The claimants are suffering.
No, since they have undertaken to effect service by Dastemut,
Much.
that one.
Well,
And also heard Mr. Zaimullah, Learned Counsel for the opposite party number 1. Office note dated 23rd/6/2025 indicates that no step has been taken upon respondent number 2 and unserved notice in respect of the respondent number 3 written with a return without any remark of the postal department. As Borthakur submits that she may be permitted to effect service upon the respondent number 2 and 3 by Dastimut. Here is accordingly allowed after effecting service upon respondent number 2 and 3 by Dastimut. Ms. Borthakur shall file an affidavit before this court to that effect. Place the matter after 2 weeks.
Your lordship, some time may be granted, 4 weeks, your lordship.
3 weeks.
Of that age.
Item 18.
Well, there is an office note which shows that the respondent number 1 has refused to accept the notice. Therefore, my lord, my prayer would be other respondents have been served. My prayer would be, my lord, your lordship will deem it to be served.
Is there any urgency in the matter?
My lord, in fact, there are 2 IAs. I will not trouble your lordship with those IAs today. One is for an injunction, one is for a my lord stay. Let those matters come after the vacation. But your lordship will, my lord, presume the my lord service. Since my lord, the notice has been refused. So far as those 2 IAs, my lord, listed today, I will not trouble your lordship on that. Let it come after vacation.
Okay. Heard Mr. M.K. Sodure, Learned Senior Counsel assisted by Mr.
I'm sure.
Sarna, Learned Counsel for the applicant. Office note dated 17/6/2025 indicates that notice upon respondent number indicates that respondent number 1 refused to accept notice. Then as such, notice deemed to have been served upon respondent number 1.
Others have already been served. But they have not filed any wakalatnama as yet.
And notice upon respondent number 2 and 3 as per office note dated 1/5/2025 deemed to have been served. Place the matter after vacation.
For consideration of the IAs. my lord.
for consideration of the interlocutory applications.
Highly obliged.
The matter is passed over timing, my lord, my senior submit, my lord.
Who is your senior?
But he's, my lord, it's coming, my lord. KKD, my lord.
After some time.
Item 20.
Action, your lordship. Give a direction, you deposit an amount, your lordship. And as the last order, your lordship, the check has already been dispatched and will be reaching here within 2-3 days, your lordship.
The amount has been disbursed.
Yes, your lordship. From the Kolkata, your lordship, from the head office of the insurance company, and it will reach Guwahati within 2-3 days, your lordship. Matter will be fixed immediately after vacation, your lordship, the reopening of the first date, your lordship.
No, you have been granted only 1 week time to deposit the.
Lordship, that is true, your lordship, but already we have communicated, your lordship, the company, and they have informed the head office also. So from there it is.
Do you have any document to show that the head
Right
office
now,
has
your lordship.
disbursed the amount?
Right now, I don't have it.
This has been going on since 2022.
Then we will recall the stay order.
Lordship, till the deposit of the debt, your lordship, that will be time.
Pardon?
Whenever we deposit the amount, your lordship, till their debt, your lordship, the stay may be invoked, your lordship.
No, you show me the communication you have received from the head office.
Right now, I don't have given some time.
Then on what basis you are submitting it?
Lordship, I have instruction from the company, your lordship. Oral instruction, I have even visited the office also, your lordship, the insurance company. Order is of 2022, your lordship, but there's a lapse on our part, your lordship, in informing the insurance company, so that delay has been occurred.
Okay, after 1 week then we'll see. Heard Mr. Emali, learned counsel for the applicant, Mr. Guragoi, learned counsel for the opposite party. Mr. Guragoi, learned counsel for the opposite party on instruction submits that the amount has already been disbursed by the head office. Then the place for listing a matter after 2 weeks. However, considering the facts and circumstances of the record, it is provided that the dismissal is the matter after 1 week.
My lord, on failure of depositing, my lord, observe that on failure of
We'll
deposit.
take care of it on next day.
21.
Lordship, we need two more weeks time to file the affidavit with regard to the dusting, my lord.
Heard, Mr.
B. Saikya, my lord.
P. Saikya, learned counsel for the applicant, and Madam R.D. Mazumdar, learned counsel for the respondent number 1.
2.
1 or 2?
2.
Respondent
One is
number
the
2.
claimant because he's the owner of the vehicle.
And Saikya submits that.
2 and 3. 2 and 3.
2 and 3.
Yes, Lordship. Insurance company.
Learned counsel for the applicant submits that he may be granted 2 weeks time to file affidavit in respect of service of notice upon the respondent number 1
Yes, my lord.
by the same of there is accordingly allowed recessal is the matter immediately after reopening.
My lord, can it be on 16th of July, my lord?
Okay, 6.
Much obliged, my lord.
23.
And your blessing.
My lord, I am for the claimant petition applicant, my lord. They deposited some amount, my lord.
I have deposited, initially, they have deposited the 50% of the awarded amount. Then, after filing the review application, this lordship is directed to deposit the rest amount. So already deposited, you can withdraw, but subject to condition to furnish the immunity one.
Why?
Because we have challenged the DL. DL is very important. That is not considered
No,
by
my-
this court.
Earlier also they only identification is there.
The, my lord,
There is-
I was not there, but it is brief was transferred to me subsequently. I have no otherwise no objection.
Okay, heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for the applicant. And Mr. Pal for respondent, opposite party.
Yes.
This application is prepared by the applicants. Namely Mohammad Gohar Mullah, Mohammad Batsa Bhuya, and Mohammad Pulsan Ali. Who is the applicant here? Pulsan Nisa, my lord.
Pulsan Nisa, government Mullah already died.
Okay.
Government died. Case 3, madam.
This interlocutory application is prepared by Mrs. Pulsan Nisa for releasing 50% of the awarded amount deposited before the registry of this court by the appellant insurance,
Not available, my review petition.
by the review petitioner. By the review petitioner. The learned counsel for the applicant submits that pursuant to the order plus in a review petition number
24 of the 24.
20,
4 of the
24.
24 of 2024. Passed by
In IML, there is IML 585 million. Money is deposited on that order, on the basis of that order. IA 585 to 24 million. Therefore, is there.
exhibit, my lord, annexure.
no, person to order pass in the review petition number 24.
24, but IA is step decision is there, Miller. Step decision is there, Miller.
No.
IA.
Annexure A, page 7, madam.
Order was passed in
This is the order, madam.
IA number 585 of the 2024.
No, the amount was deposited pursuant to the order passed in review petition.
Yes.
No, IA.
IA.
IA
585.
review petition.
IA in 5.
File
No,
IA.
amount was reviewed pursuant to the order passed in review petition.
Yes.
Review petition is different, Miller. Then step petition is there, Miller. That is IA number 585.
IA
Okay,
was
okay, please sit down. And also, person to the order passed in. IA number 585. The balance amount of the original award is deposited before the registry of this court. And the applicant may be allowed to withdraw the said amount from the registry of this court. Mr. Paul Learned, counsel for the insurance company submits that subject to executing a bond by the applicant, she may be allowed to withdraw the aforesaid amount. By taking note of the submission of learned counsel for both the parties, the applicant is allowed to withdraw the balance amount from the registry of this court subject to executing a bond of equal amount. In terms of this, IA stands closed.
Number 24.
Made resolution. My lord, here, my lord, I have filed in Miss Case 2009. The facts of the case, if your lordship permits me, my lord, I find a suit for right title interest
and confirmation of possession against the defendant. I have purchased the plot of land going through the procedure through a registered sale deed. And after that, my lord, the private respondents, they went for a mutation and saying in the revenue authority and tried to cancel my mutation. My lord, I came before the civil court with a prayer for right title interest, confirmation of possession, and for declaration that a mutation order cancel is bad in law. And the trial court passed an injunction order in my favor, my lord. The injunction order in my favor. Then I took steps. They appeared before the trial court. After they appeared before the trial court, they prayed that in the injunction application and the plaint, some annexures were not there. And I filed an application for extension of my injunction order. And that was rejected, for which I came before this court. And my lord, the court passed an order of injunction status quo, and the injunction application there has been stayed. My lord, now, my lord, I am in possession of the land. I have everything, my lord. They don't file written statement. They don't file any objection. Neither they appear, neither they don't allow me to construct over my own land, my lord. That is my prayer in this case, my lord, that I have in possession at my risk and cost. I may be, this is my suit. I will start my construction. That much is my prayer, my lord. Because they don't do anything. Neither they appear, their names are shown, neither they file written statement, neither counterclaim, neither anything objection. They just physically, they want to disturb me, man. I want to construct over my plot of land. My lord, your lordship, in the FAO, your lordship will find that registered sale deed, everything was there. And the order of rejection, your lordship will find at page 67 in the FAO. My lord, only because that
No, is
some,
it not part of this IA?
my lord,
Is it not part of the IA?
my lord, in the IA, I have made that,
Annexure A?
yes, my lord, it is there, my lord. Annexure
So
C,
what
page
is the
16.
ground?
My lord,
What is the ground?
ground for, my lord. Sorry, my lord, ground. Ground, that, my lord, that ground for rejection, my lord. My lord, at page 16, Annexure C. The petitioner represented and filed petition sought extension of order of ad interim temporary injunction. Her prayer is rejected. Necessary compliance for order was not, which leads to vacating the order. OP number 123 have appeared through their duly engaged counsel, filed petition, sought furnishing of copy of the plaintiff document relied on by the petition. That is the ground for not extending my interim order. Though they have appeared, I have taken steps. That was the ground for not extending my interim order. Then I approached this court, and this court passed an order, my lord, that is, I have enacted at page 17. At page 19, the order is there, my lord. Now this I find, my lord, just for construction, my lord. My land, I am in possession, I have done everything, my lord. If I cannot construct, I will construct at my own risk and cost, my lord. Their names are shown, they don't appear, they don't file anything, my lord.
But the learned trial court has found all the three principles in favor of the
Petitioner, me, I am the petitioner. I am the petitioner, I am the plaintiff. I am the plaintiff, I am the petitioner. It was not extended because, my lord, only because they have appeared that they have sought for some documents of the injunction application and the plaintiff. That was not extended on technical ground. But they have appeared. We have taken steps. And the present IA is, my lord, 2009, where I have sought for, my lord,
FAO is already admitted.
admitted. I think it's admitted.
Okay, we'll see. Where is your cell date?
My lord, in the FAO, it is there, my lord. Your lordship will find.
Page number.
I'm placing, my lord. Delete the background now. Delete. Yeah, title suit, this is title suit, plain sweep. So just for a moment. In this case, then. That's my notice. Just a little now. Page 39. দিল্লিতে কোথায়? Thank you. They have appeared, my lord. My lord, I can give my plain copy, my lord, before your lordship, the total documents, the sale deed, everything is there with that, my lord. The plain copy. Your lordship may look into, this is the plain.
So have you received the copy of this IA?
Yes, sir.
I received the copy. And Lordship, in this matter, in trial court, Lordship, the trial court already give several directions to supply copy of the plaint and other documents to us. But till that, Lordship, they have not supplied.
We have
In
taken
trial
steps
court
through
also.
Jari Karok. We have taken steps to Jari Karok.
And regarding Lordship, FAO,
No, FAO is already admitted. Now there is one IA.
IA 200 now. I am in position, I need construction.
of the building.
Yes.
But Lordship, where he was want to, where he want to construct the building, this is the main shoot land, Lordship. So how it is possible, Lordship? At this stage.
At
And
my
Lordship,
risk and cost.
regarding other defendants, Lordship, notice not served till date. Except 1, 2, and 3, Lordship.
How many respondents are there? Opposite parties are there?
8.
8.
8.
Those are pro forma. 4 to 8 is pro forma. We have sent copies through Jari Karok in the trial court. 4 to 8 are pro forma. Main defendant 1 to 3. They are the 1 to 3.
You want to file objection here?
Yes, Lordship. In I objection.
But only thing your lordship may understand, I am in occupation, I am in position. My lord, they have not till date, I have served copy, and in the FAO, they have not brought it before this court. Neither they have filed for vacating of the interim order. My lord, they are sitting over there. Now the issue is, my lord, neither I in my land, at my own risk and cost, I will construct, my lord.
No, Mr. Chaudhary. Fair opportunity has to be given to the other side.
My
also.
lord, they have received copy for a long time in this FAO. They have not filed any objection.
No, this interlocutory application.
My lord, they are saying that objection is that this is the main suit land, I cannot. My lord, that at my own risk, I will impose, your lordship may give me an indemnity bond that if I, and neither they have filed any counterclaim, neither they have filed any suit. How could they, my lord, if I am in
But
position?
Lordship, regarding filing of WS and counter claim, trial court repeatedly direction to the plaintiff that supply copy to the defendants. But till that, Lordship, this is the certified copy. Till that, they have not supplied.
My
And
lord, we have
regarding
taken
Lordship,
Jari Karok.
injunction order, Lordship, they have take one in order 39 rule 1 and 2 petition they have filed, and one expertise order was passed, Lordship. And main direction of the court was that they have to take steps upon the respondents and compliance is required to be submitted, Lordship. And as per order 39 rule 3A and B, they have not taken steps, Lordship. They have only supplied one certified copy to us, Lordship. Like this. This is the injunction order state, Lordship.
But we have given everything to a registered post.
No.
Court cannot take up this way, my lord. No registry will take up matters that way, my lord. No registry in any court of in Assam.
Court supply the copies, and we have not unable to file the WS, Lordship, in the case.
No, you
And
want
he said,
to,
Lordship,
no,
this
no,
petition is not
you
maintained.
want to file objection in this IA or not?
Yes.
Let him file objection.
Then, my lord, because my lord, this is the last opportunity given to them, my lord, they have received, on 15th, it will be listed on 15th, my lord.
Heard, Mr.
15, because no- July 15.
applicant. That also heard.
This is your problem, with some.
Your good name, please.
As a Adhyapok.
As a
Adhyapok.
Adhyapok, learned counsel for the respondent number 123. This application under section 151 of the Code of Civil Procedure is filed by the petitioner for allowing him to construct RCC building over the supply. The learned counsel for the respondent opposite party number 120 submits that he will file objection in this petition. And price for granting him supply. Here is accordingly allowed. This is a list of matter on cover.
On 15th, my lord, because I'm 15 July.
After 20. First 20. 20,000. 25.
May I please, your lordship? Lordship, this is an IA for delay condemnation, my lords, for 11 days, my lord, and filing the connected revision against the, my lord, Miss Appeal number 18 of 23, my lord, impugned order dated 9/2/2024, my lord. At this stage, my lord, no.
Heard, Mr.
Why would we on behalf of Mr. H. Gupta, my lord?
Learned counsel appearing on behalf of Mr. H. Gupta, learned conducting counsel for the petitioner. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condemnation of value of 11 days. In filing civil revision petition against the judgment and order dated 9/2/2024 passed in Miss Appeal number 18 of 2023 passed by the learned additional Session Judge number 2 FDC in Sukia in connected civil revision petition. Here is the application and the documents placed in record. Issue notice to the respondent, returnable in 4 weeks. Respondent opposite party, returnable in 4 weeks. Step be taken by registered post Wikipedia and also the usual process. Okay.
Much obliged.
List of products.
There is a delay of 10 days in preferring the appeal matter. I civil 2021.
Okay.
27.
Like,
May I please? So there's a delay of 69 days, notice,
69
69 days.
after 4 weeks.
28. Well, Lord, step by registered.
What?
28. May I please, for those who delay petition, first time lordship, notice may kindly receive.
What?
For first time lordship, for 2211 days, but COVID period is not minus. It will be lesser.
Okay, this one notice.
So,
After 4 weeks.
29.
Lordship is IS for delay of 14 days, Lordship, in preparing the connected secretary.
1/4.
Lordship, the health issues, Lordship, he wasn't able to, 14 days, Lordship, delay.
Okay. Let notice go at this surface.
Lordship,
After 4 weeks.
obliged, Lordship.
30. My lord, I seek time to file objection, my lord. In this matter, yesterday we have received another application by the learned Labour Commissioner. There is not little list.
There is application for implement, my lord, as simple as that. I am the person, my lord, on the basis of whose information, my lord, the entire proceedings began. And I am also an implicated party in the proceeding before the learned labor court.
My lord, it is
So
listed.
why objection in implement?
My lord, even in the learned trial court, the labor court, we had filed the objection. Let our objection at least come on record before the hearing is done. My lord.
because they are trying to
But in,
be implemented as a party, my lord. It is the organization whose registration was cancelled by the Labour Commissioner. Against that, we filed an appeal and an injunction application was filed. That injunction application on being dismissed, we approached this honorable court, and your lordship had by order dated 26/3 had passed an order staying that order. And my lord, today they have filed an application for impediment. I seek some time, my lord, to file objection. There is another application filed for vacating, my lord.
Let them file objection.
in that case, your lordship may not grant much of time. Can let it be taken up on 14th reopening.
My lord, I pray, my lord, my senior will appear in this matter. He is not there, my lord. On 24th, if your lordship may take it up.
Oh, that will be-
24th of July.
July.
Yes.
No.
Before that, my lord, may
it's
file an all objection. Before 24th only we'll file on reopening, we'll file our objection, and thereafter, my lord may take it up for here.
Well, the problem is that, Miller, the matter is pending before the learned labor court. Date, that is on 7th, that is on 7th of July. That is on 7th of July. They have been given time on repeated occasion to furnish the documents to place the evidence. They have not done. They are dragging the matter on this pretext and the other.
No, my
And
lord,
today-
last date we had furnished the document.
No, only one
You
document
file-
was filed, Miller.
Next that is 14th. Okay,
My lord may fix it on 23rd. We'll file our
No, no.
objection and it can be taken up for
Sorry.
hearing, my lord.
let it be on 14th. Third minister is Dr. Learned Counsel.
Can it be on 15, my lord? 15th, my lord. I am the respondent number 1. My lord, if your lordship permits me, the whole thing started when the registration.
No,
of-
you file objection, we'll hear.
No, I'm not on the objection. I'm just praying for a date to fix on 15th instead of 14th.
Okay. 15th. Third minister is Dr. Learned Senior Counsel, assisted by Mr.
Yes, please.
Learned Counsel for the applicant. Then Mr. Batra for respondent number. You are for respondent
My
number.
lord, I am for the actual revision petitioner, my lord. Commission Regis here in the IA, I am the opposite party number 1. my lord.
Opposite party number 1. Then Mr.
S. Chakravarti for the respondent number 1 in the
S. Chakravarti for the
representing the Register of Trading.
register.
Register of Trading.
Register of Trading. And here you are a party, yes, opposite party number 2. Opposite party number 2. This application under order 1, rule 10(2) of the Code of Civil Procedure, it is section 151. The Code of Civil Procedure is prepared by the applicant for implement. To allow the applicant to be added as a party as a respondent in CRP IO number 85 of 2025. Mr. Batra, Learned Counsel for the respondent number 1.
Opposite
Submits
party,
that
my lord.
he may be granted some time to file objection. Where is allowed, SSL is the matter on 15.
My lord, the interim order passed earlier may continue because the CRP is also listed. my lord.
CRP. Okay.
It is already there, na?
Yeah, my lord, that may continue till the next day.
Interim order passed earlier, CRP continue.
Till the next
Okay.
day. The next day. Because this order, interim order was.
Okay, till next day.
Pending item 19.
May it please your lordship. The second appeal has already been admitted by the order dated 4/11/24, formulating the substantial question of law. And the nullity of the judgment itself is a substantial question of law in this appeal. Lordship, along with the appeal, we filed an application for staying the proceeding of the decree. And in paragraph 7, we have specifically stated, because we have noted decrees for eviction. And in paragraph 7, we have specifically stated at page 10 in our petition, presently the appellants are in possession of the suit land, and if the said decree is executed during the pendency of the instant appeal, the appellants will suffer a loss, injury, and the appeal may become infructuous. They have filed the objection, lordship. In paragraph 6, while replying this, they have said that at page 18 of their objection, the deponents said that the appellants are permissive 18, serial number 18, page number 18 of their objection. Para 6, statement admin, paragraph 7 to 10. The deponent said that the appellants are permissive occupier has no legal right to possess the wetland. So till today we are in possession and eviction order is there. Nullity is involved as a substantial question of law. Lordship, and in this petition, Lordship, they have not mentioned anything regarding the initiation of the execution case. After receiving this objection, Lordship, we have searched and I come to know that execution case already been started, but we have not received any notice regarding this. We have obtained a certificate copy only for the purpose of this pendency. Since Lordship, this appeal is admitted, Lordship, I pray, Lordship, the execution case may be stayed. They have not mentioned anything in their objection regarding this. We made an inquiry and come to know. And the next 26/6 is the next date before the executing court, Lordship. So it is a fictitious, Lordship.
Yes, Mr. Day.
The appellate order was passed 1 year back, my lord, on 15/7/2024. And this matter is very short, my lord, whether the decree was passed against a dead person or not. Your lordship may hear the entire matter, my lord, record is here immediately after the vacation. Instead
Till
of,
then,
Lordship, early hearing, no problem, Lordship. Till then, Lordship, because they have already filed.
because we have already admitted the appeal. So if the decree is executed in the meantime, then the appeal would be in us.
lordship fix up a date for hearing, my lord.
We'll
It's
fix
very
a date
short,
for hearing,
my
but
lord.
till then, this
My
entire
lord.
application. Or Mr. Z. Ekal, or net counsel for the applicant, and Mr. KK, or net counsel for the respondent. This application is referred by the applicant for staying, for staying. Operation of the impugn. Order dated 15/7/2024, passed in title appeal number 7 of 2023, as well as the judgment and decree dated 28/7/2023, passed in PS number 162 of 2016. Mr. Dekkal, learned counsel for the applicant, submits that connected regular second appeal has already been admitted by this court, and the respondents have entered appearance, and the LCR has also been received, and the matter is ready for hearing. And in the meantime, the respondent hearing has instituted title execution proceeding
1/24.
in TX01 of 2024, wherein the learned executing court has issued notice and
26/6/25 is
also directed the decree holder to clarify the schedule of the decree till length and takes the matter on 26/6/2025. And since the RSA is ready for hearing, and if in the meantime the decree is executed, then the RSA would be rendered infractious, and as such, the contended to stay the same till disposal of the RSA. Mr. Day, learned counsel for the respondent opposite party, however, oppose the petition. And submits that the RSA was admitted 1 year back.
No, RSA normally impugn order, impugn appellate order.
Impugn order was passed in 1 year back. 1 year back. And since the matter is ready for hearing, Mr. Day submits that the entire matter may be heard and disposed of immediately after reopening of the vacation. Taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, and further, considering that the RSA is ready for hearing, this court is inclined to allow this application, staying the operation of the NPM order and the judgment and decree till disposal of the RSA number 201 of 2024. Since the LCR has already been received and the parties also entered appearance and the matter is also ready for hearing, Recess will list the matter on 7th of August for hearing.
In the interim portion, the title execution number, if it is that. Oh, obligatory.
31.
Four days delay in filing the connected NC appeal.
4 days. Okay. Next step.
Publish.
32.
Appeals, Your Lordship. 6 days delay in filing appeal, Lordship.
6 days. Okay. This one notice.
33.
May it please Your Lordship, delay of 20 days in filing the appeal.
Okay.
Obliged.
34.
28 days, Lordship. Apply, Lordship.
The number 40.
May please your lordship.
40.
May please your lordship. As per this honorable court order, we have taken steps upon response number 5 and 6 by way of publication of notice in the newspaper. And in this regard, we have also filed affidavit. Affidavit.
You have filed?
Yes, lordship. That is tag in the right.
Okay. Heard. Heard, Mr.
NM Dutta.
NM Dutta, learned counsel for the appellant, and also heard Mr.
B Prasad. B Prasad for respondent number 1, 2, 3, and 4.
B Prasad.
For respondent number 1 to
Counsel
4.
for the respondent number 1, 3, and 4. Mr. Dutta, learned counsel for the appellant, submits that pursuant to order of this court dated 13/6/2025. When the order was passed on 30/4/25.
Yes, sir.
34.
Pursuant to order dated 30/4/2025. The notice upon the respondent number
5 and 6.
5 and 6 were published in the local daily, namely Dainik Assam, published from Guwahati, fixing the matter on 13/6/2025 at 10:30 AM for appearance of the aforementioned respondent in the court. And he has filed an affidavit to that effect enclosing the said paper along with the affidavit. In 2 papers.
In 2 news.
Two news, sir.
One in Assam, the Assam Tribune,
and Dainik
one in
Assam.
Assam Tribune, and also in the Dainik Assam. Dated
Both the newspapers are dated 23/5/2025.
both are same date?
Same.
Same date.
Same date. And since no one entered appearance on behalf of respondent number 4 and 5. No, 5 and 6, notice deemed to have been served upon them. And since the service has already been completed, the matter is ready for hearing then?
Yes,
Ready
Lord.
for hearing, my
And
Deep medical.
the matter is LCR received
Receipt, Lord.
and the matter is ready for hearing and the LCR has also been received. Then accordingly it is contended to list the matter for hearing. We are taking note of the submission of learned counsel for both the parties. It is provided that RSSR list the matter for hearing.
In the month of August, second week of August.
14th August.
I am 41. Obviously.
May I please, Your Worship? In this case, now, the appeal has been admitted and LCR was called for, that has been received. And on the day of admission, my lord, stay was granted. On the next date fixed, my lord, it was not extended. So that may be extended, otherwise the case is ready for hearing, my lord.
No, this interlocutory application has already been allowed. Title execution case number 1 of 24 state till disposal. No, till returnable date.
Till returnable date, that is very good.
When the date was fixed.
My lord, on September 2014.
Yes, madam, any
19/9,
objection?
2000.
Okay. Part Mr. Sahu, learned counsel for the applicant and madam.
DDV.
David, learned counsel for the respondent opposite party. Mr. Sahu submits that the second appeal has already been admitted for hearing. Whether record was called for?
Yes, my lord, record.
Received.
As per cause list, it is, my lord, recorded there.
And the LCR has also been received. The matter is ready for hearing. And there is a requirement to stay. The execution case number 01 of 2024 till disposal of the appeal. The learned counsel for the respondent submits that he has no objection. We are taking note of the submission of learned counsel for both the parties. Title execution case number 01 of 2024 stands stayed till disposal of the RSA number 103 of 2024. In RSA you take down hard basis so and so. Learned counsel for the appellant and respondent. LCR has already been received. The matter is ready for hearing. SSL lists the matter for hearing. In usual course.
Can it be this vacation in the month of August because they did not challenge the title suit judgment. The judgment and decree passed in my favor. We filed an appeal rather challenging the judgment passed by the learned trial court because the calculation of the advance amount was not determined properly by the learned trial court. They for the first time came before this honorable court challenging the judgment passed in the title appeal. It's a specific performance of contract case, merely an amount of rupees 3 lakhs involved. But in the month of August,
28 August.
much of that.
But is it necessary to challenge that judgment? Trial court, because it stands merged with the appellate court
Yes,
judgment.
my lord. It has been
That's a
merged with the
decision of
appellate court
Supreme
judgment, but it has been merged with the appellate court judgment. But the trial court finding, the finding was in favor of the plaintiff. Here, the finding is with regard to the advance amount only. So far as the specific purpose of contract case was concerned, the decree was granted in my favor. That decree they did not challenge in the appeal. In the appeal, my lord, we challenged the rather decree saying that the compensation amount, which was the amount of advance amount determined by the court, was incorrect. So here the court came to a finding that the advance amount which the learned trial could determine was 1 lakh. It is 2,34,000. This is the only difference.
Yes, that's close.
42.
Your lordship, kindly see the order dated in appeal. Order dated. My lord, 24/2/2025. IA number. IA number, my lord. IA 3742. Order dated 24/2/2025.
So,
3742.
So this interlocutory application is for vacation of interim order.
My lord, a order was passed on 34/3742. Your lordship can see order dated 24/2025. That I filed an integration application for stay the proceeding. This honorable court has stayed the proceeding, and my friend was that order has been passed in presence of my friend.
Lordship, but I would like to highlight
Then-
one thing.
then
Lordship, we have
he-
not received the copy at that time.
Then, my lord,
We did
he
not get the opportunity to argue on that.
then he that time asked
It was
to
reflected
file
in the
one
order
to file
itself.
objection for that IA. They took time for filing objection. Time has been granted. Now, you also kindly see, matter was listed on main RFA, my lord.
No, okay.
Order
Do you
dated-
have any objection in
No,
Lordship,
no, because-
Lordship, we have filed the IA number 1939 for vacation of stay.
My IA, they file IA. It is permissible, my lord.
Lordship, to
They
vacate
took
the
time to
stay, we
file
have filed the
objection.
IA.
They may file objection.
For Lordship, let me submit, it is my
No,
application.
that is not a matter. Is this honorable court fixed the matter for hearing by order dated
But Lordship, since
24
the matter is fixed for hearing,
24/4/2025 in RFA, my lord. Order dated also can be said. Order dated 24/4/2025. Heard Swensu, London County Appellant also heard Mr. Swensu. It appears the record of trial court has been received and both the parties have prepared. List the matter listed for hearing. There the matter was listed for hearing 2 times. And last occasion also matter was listed for hearing. My friend has taken time.
I
Last
have not
occasion,
taken
last
time,
occasion.
Lordship, this is wrong.
No, my lord, I am ready for hearing. I am ready for to take the entire hearing. I am ready. And now my friend has filed IA in IA, my lord. It is permissible. It is not permissible. It is, he can file objection in my IA. Stay was granted by this honorable court. He has taken time to file objection. He may file objection, but he filed IA against IA. That is not permissible, my lord. So intermediate heard, order is there, matter is taken listed for hearing. I am ready. It is first appeal, my lord. It is a first appeal. I filed this appeal as a matter of right. And this honorable court necessarily pass an interim order. If the interim order is vacated, there is no purpose for remaining the appeal here, my lord. That is why this honorable court fixed the matter for hearing and matter is listed. And somewhere on that day matter cannot be heard. So any day, today I am also ready in after vacation.
Let me submit, Lordship, let me submit on this application, Lordship. My learned senior friend said that on last occasion I took time. Actually, there, due to some
Then without
difficulty, court
informing,
could
no
not take the
matter.
hearing on that date. Let me submit. Prior to that, Lordship, my learned friend submitted that we should not make any additional prayer in the petition, in the title suit. That was his ground. So, Lordship, it is also reflected in the order dated prior to this order. Lordship, it is also reflected that time was granted to my learned friend to inquire, whether an additional prayer can be made or not. But it is also there in the specifically section 22, Lordship. We can make that prayer. Now we filed this petition, Lordship, because on 6/5/2025 this month, Lordship, when we visited the acquaintance of my one of my acquaintance, that is situated in the close vicinity of the suit land in question. I saw that there some raw materials have been dumped in the suit land and construction have been started. Lordship, I have also annexed the photograph of the said construction. Lordship, that annexure C in my stay application, page number 14, 1939. And I have also filed FIR. There is annexure to annexure B, page 12. That is why I filed this IA for vacation of the stay, Lordship. Because there is an injunction order. Despite there being an injunction order, they are doing all this.
There is no such injunction order, my.
There is an injunction order.
That
Lordship.
order
There
has
is an
been,
injunction order.
There is
In
a
the title
order.
suit, Lordship.
Same, I am not going to any construction, nothing, my lord. And Lordship, even today I am ready for hearing, my lord. If my friend, I am ready for hearing. Yes, I am also ready, my lord.
I am ready.
I am ready. It doesn't matter because it's the first appeal, my lord. First appeal, if without stay, we are in possession in the land, you did stay, my lord. And then my appeal will be infectious if Lordship.
Lordship, right now, my friend, my
That is
dear
why.
friend.
That is why this
he is
no
in
could
possession
only
of the
pick
land.
the matter for hearing.
Doing the construction. I have also annexed the photograph of the same. I have also lodged the FIR. He himself claimed that he is in the possession of the land.
Mr. Ahmed,
My lord.
so till disposal of this appeal, why you are undertaking this work?
My lord, no works, my lord, no works.
This see the photographs.
Photograph is earlier photographs, my lord.
It is not,
Earlier time it's
Lordship, that is
It
written
is bounded,
here.
earlier there is a boundary.
That
As
is
it
written
is,
here.
land is as it is, my lord.
This is
Boundary,
Lordship, that is written here.
on the boundary, my lord.
With time this time I have taken the photo. That is written here. It is 6 June 2025.
There is a boundary, land boundary is there, no construction.
We have also lodged an FIR.
No
There is
construction.
an injunction. How
Maybe if they lodge a FIR, inquire the matter, police.
Ahmed, you see the photograph.
My lord,
You see the photographs.
I have seen the photograph. Those are boundaries, my
So
lord.
this was taken
Temporary
on-
boundary.
The land,
Relatively
it is the
see,
plan load
the
where they have
temporary
dumped this raw
boundaries,
materials.
there, my lord. As it is. Now, no new construction, nothing.
It is
Nothing,
newly
my lord.
dumped. It is
That,
written from the photo. Lordship.
Lordship, my lord, even though they were any fix, they will not sense a character of the land, my lord. That can be observed, my lord. They cannot make any construction, nothing. They cannot.
Lordship, despite there being an injunction, they are doing all this.
No.
Lordship, they are simply, this is their desperate attempt to deprive me from my rightful title. Which I am the decree holder, Lordship. And the suit was granted under Order 12, Rule 6 on their own admissions. If your Lordship will look at their written statement, they have admitted categorically.
No permanent construction, nothing. If they can do it, it will
I have
not be
annexed
demolished, my
the- I
lord.
have
It will be
annexed the
demolished.
photographs and
They
Lordship.
will be benefit, my lord. They will be benefit. If they
And
make
also,
any
Lordship,
such
Lordship, I have
construction, they will
also
be
annexed the
benefit.
compliance order wherein it shows that pursuant to the precept issued by the civil court, this performer defendant number 2, 3, and 4 have no locus standi anymore.
Let the hearing, it will come on in the merit, on merit, my lord.
Execution was
Yes.
Will I fix the matter for
Yes.
hearing immediately?
Any day,
Then
immediately.
Lordship may direct them not to initiate any construction or anything in the
No,
order.
he has already undertaken not to.
I don't, no, nothing, my lord, no construction.
Lordship, I have
It lost of the
photo,
vacant land,
Lordship, I
land
have
is lost of
also lodged an FIR.
it lost of photograph, all the vacant.
It is
Then it's
inside the
vacant,
boundary,
my lord.
Lordship can see. It is
Full
newly
boundary, my
dumped
lord.
raw materials.
Full boundary, my lord.
Okay. Alright, Mister, your good name, please.
B core, Lordship.
B?
Lordship may kindly fix immediately after vacation. B core.
B. Kumar, learned counsel for the applicant. And also heard Mr. J. Ahmed, learned counsel for the respondent. This interlocutory application is prepared by the applicant for staying the order of vacation. No, for vacation of the stay order dated 24/2/2025, passed in IA civil number 3742 in RA RFA number 71 of 2024. In connection with the title execution case number 22 of 2024. Mr. Kumar, learned counsel for the applicant submits that despite the order of this court, the opposite party herein has undertaken some development work in the suit premises.
No, here no injunction order. Injunction order is there from trial court.
Lordship,
Stay order.
Stay order. It is a stay order.
injunction order is there in the
It
case.
is the title suit, my lord.
They should not do any kind of obstruction when there was injunction.
Here is no injunction.
And
It is just a stay order.
referring to the Annexer C, the particular of the Suitland, Mr. Kumar submits that they have already gathered some construction material in the suit premises. However, Mr. Ahmed, learned counsel for the respondent opposite party submits that no
new construction.
No new construction work is being undertaken by the opposite party herein. And he also undertakes that till disposal of the RFA number
71 of
2024, he will not undertake any construction.
No, my lord. So far undertaking, my undertaking concern, he may be directed to not to make any construction. Because undertaking is
First
for
of all,
my
they are
part.
claiming in their
Suppose
RFA, in their injunction that they are in
It is
possession.
upon them, my lord.
Construction laws. It is their
Yes,
claim.
they may be directed not to
Claim
construct.
right
They
now.
may be directed
No,
not to
no,
construct.
in lieu of the undertaking given by Mr. Ahmed, learned counsel for the applicant, no, learned counsel for the respondent opposite party, this interlocutory application stands closed. Since the RFA number 71 of 2024 is ready for hearing and the LCR has also been received, this is a list the matter for hearing on
14th of July, Lordship, if possible. 14th of July, Lordship, because he already 5 days have been governed.
Oh, reopening them.
Hearing could not be done due to vacatur of town, Lordship, time, Lordship, may kindly fix the date.
on 14 we have already fixed.
15, Lordship, 15, Lordship, 15th of July.
15 already.
6th, 24th July. Oblige, Lordship.
25 under stay matters.
My lord, so far as undertaking part, our part is concerned, it may be directed to persons, they will not make any.
Lordship, it is their claim, it is there in their.
Because
Okay.
you not understand, the advocate cannot give undertaking.
I done 25.
My lord, I cannot give undertaking. It is one.
Which means, Lordship, they will continue with the construction, Lordship. If they,
No, my lord. Why, my lord?
because I have given the annexure source. Oblige.
May it please your lordship. The petitioner before this honorable court, my lord, is a defendant, my lord, the defendant landlord. The suit is pending, my lord. Thus, there is no stay so far as the suit is concerned. Now, while the suit was pending, my lord, an ex parte injunction was granted. And thereafter, my lord.
For my and start, my lord, the order is my the appealable order, even if it's not maintainable. The appealable order, your lordship kindly see. May I start? That order is my lord, your lordship kindly see impugn order is page 1, 2, 3.
Against injunction order.
This is against my lord, order 39, rule 2A order. Rule 2A, order 39, rule 2A, violation of injunction matter. I filed an application for violation of injunction matter, order 39, rule 2A. That order is appealable, order 43, your lordship kindly see. Order 43, my lord. Rule 1. I. The impugn order was arising out of order 39, rule 2A. Order 43, rule 1R.
Yes.
So that this should, my lord, is a order passed by the learned, my lord. Appeal light, yes, Union Division. Appeal light the, my lord, district judgment.
So, madam, you withdraw this petition and file appropriate.
My lord may consider this, my lord, they have raised a issue of law, my lord. After the vacation, let any date be fixed and we can do this, or or if this honorable court, my lord, may just give. Or this honorable court may give a liberty, my lord. In the meantime, the stay has to be there. Because
No, if you withdraw the petition,
that-
then I
that-
cannot grant you liberty.
my
No, no.
no,
I
so
cannot grant a stay.
my lord,
I can grant you liberty.
My lord, I'm just pointing out, this petition is not under section 115 only. It is, the article 227 also has been invoked. And considering this, my lord,
Madam, there are several decisions
my lord,
and also a decision of division bench of this court that against this violation of injunction order, only the appeal will lie.
my lord, I'm not saying a yes or a no just now. I'm saying that my learned friend has raised a legal issue. Let it be listed after the vacation. I will answer this issue. If it is not maintainable, then I will have to go back. If it is maintainable, I will pursue this on
Okay,
court, my lord. That is only my, at the
Third
moment.
is B.S. Goel, Learned Counsel for the petitioner, and Mr. T.J. Mohanto, Learned Senior Counsel, assisted by Mr. for the respondent. During the course of deliberation, Mr. Mohanto has pointed out that this civil revision petition is not maintainable in view of Order 43, Rule 1R of the Code of Civil Procedure. Ms. Goel submits that she may be granted some time to go through the aforementioned provision and contended to list the matter immediately after reopening of the vacation. Here is accordingly allowed, this is list the matter
On 21st or 22nd, subject to my learned friend's
I am
convenience.
always available.
Okay. 21st.
Yeah, my lord. Because I'm so grateful, my lord. My lord, till then, my lord, that stay has to
Till
continue.
then, interim order for service.
I'm so grateful, my lord.
For hearing 43, 44.
My lord, I'm sorry to mention one thing, my lord, in item number 24, in the miss case where my injunction was there, the interim order was still today. That has to be continued.
Pardon?
Item number 24, one application miss case was for construction. Your lordship has given the opportunity other side to file objection. And another miss case where the interim order was there, that has to be extended.
Okay.
Item number 24, miss case, that miss case fund. Miss case number was 3417.
Okay.
3417. The interim order has to be extended. Obligement.
My lord, in this case, my lord, the 44 I am, my lord, my learned friend is 43, my lord. In this case, my lord, as per the last order, it is on 18/6, my lord. They, my lord, director was supposed to file the affidavit, my lord. So they have filed the affidavit today. So I have to gone through, and I am not aware, my lord, my learned friend, my counterpart, whether his case is similar to me or I am not aware. Just I have came to know, my lord. And second thing, my lord, as the affidavit has been filed, so my prayer is, my lord, I have to go to and let's say matter will be long to be length to be hard on, my lord, 24th, my lord, of July. So that on that they may be disposed of. It is remaining to be pardoned, my lord. Is it not possible then after
24th.
on 24th July?
Okay, okay.
Both the matter.
Lordship, my learned friend has made a request to take this
Yes,
matter. Whether the lordship, I don't know about the facts of the my learned senior friends here.
Okay, in the meantime, you go through it.
Yes.
So will I direct the rest to list both the matter together?
On 24th of July. No, it is not possible on 29, my lord. My lord, they are only, my lord, formal party. They are not any relief against them, my lord. They are not the implementing authority, my lord. They are only the formulating the guideline. So they have nothing to say, my lord. They are near, her presence is not required. One assistant may be enough, my lord. It's not necessary, my lord.
Does not permit us to send out
Nothing to
DVS.
do, my lord, UGC. UGC only formulated the guidelines, my lord. Their junior may be appeared, my lord.
Lordship, UGC does.
Is
not
her
permit
presence is not necessary. I am unnecessary, my lord, made the
In my
party.
case, Lordship, UGC is
It's
not a
not
party.
required, my lord.
UGC is not a party.
Not a party in this case,
And
my
both the matters are part heard before Lordship. So part heard is
UGC is not required by presence is.
Already part heard.
Junior may be sufficient, my lord. They have nothing to say anything.
UGC doesn't, there is a wakalatnama and the wakalatnama has only my name. They do not accept any kind of orders in which the junior appears or somebody appears. Otherwise, I would definitely have.
No, if the matter is urgent, you see, one of the matter is of 2017.
Yes, my lord.
And the other is of 2023.
Lordship, that is why I'm just praying for, if it could be on 25th also, I don't have a problem.
2050 is a hearing.
Friday, not
It's
for
a Friday. That is why I prayed for 29, Lordship. After 24, the only
24,
hearing day is
yes,
29.
24 Thursday, 29 Tuesday.
Yes. After 24, the next hearing date is 29th only, Lordship.
29.
My lord, but her my lord statement is nothing, my lord. Only is they are formulating the guidelines. Ultimately, implementing is the government, my lord. They have nothing to say on that.
Paid a party. I will have
This,
to-
unfortunately, I'm not the party, my lord. This I am not necessary, but I, for sake of my lord, this security, my lord, of the cases, then I made the party. This is it, my lord.
Third Mr. P. Mohanto in title number 44. Learned Counsel for the petitioner and Mr. D. Upamanya, Learned Standing Counsel for the respondents in Higher Education Department. And Ms. Agarwala for respondent number,
Respond number 3, Lordship.
respondent number 3. As agreed by Learned Advocate for both the parties, this is the matter on 29.
29 July.
29.
29.
My lord. Possible.
Second.